Hello friends, just now we have learned the kinds of suits to be filed in courts of civil courts. Okay. Now, in which court you would file a civil suit? Okay. In which court? Normally, Section 9 of Civil Procedure Code 1908 says that civil court shall try every suit of any nature, excepting the suits the cognizance of which has been expressly or impliedly barred. Meaning, my friends, you can file a suit for any relief in respect against anybody in respect of any property or any civil rights, but those suits should not be barred expressly or impliedly. And what is the bar? For instance, my dear friends, take the SURFACI Act. SURFACI Act 2002. Securitization and reconstruction of financial assets and Security Interest Act 2002. This act specifically prohibits the jurisdiction of civil courts as per section 34 or 35, whatever it may be, you go through it. And instead of civil courts, another forum has been established, that is called DRT, Debt Recovery Tribunal. Okay. And in Waqf cases, Waqf Act, whatever the property Waqf is, you can't go to civil court. You have to go to the Waqf Tribunal. Likewise, Hindu charitable institutions, they need to go to the Endowments Tribunal. Okay? Endowment Tribunal. These are all called the express bars, which prohibit the civil courts from trying the suits. Okay? These are only the examples, instances, not the whole express bars. Okay? And for example, another example is company law or IBC, Insolvency and Bankruptcy Code. Only the cases relating to those acts, under the provisions of those acts, shall be tried by NCLT, National Company Law Tribunal. Okay? And another forum is there in New Delhi for trying of cases of under the provisions of Competition Act. Okay, business competition among the businesses. Okay, for regularization of the businesses, like this. And coming to bar by implication, implied bar means, for example, you can't file a suit seeking a direction or relief against a police officer to register a case. That is implied. You can't file a suit against the Tahsildar for not mutating your name in the revenue records. Those, such actions, illegal actions or inactions of the government or other parties can be challenged in the High Courts under Article 226 of Constitution of India. Okay? This is literally Section 9 says the civil courts shall try all suits excepting the suits which are expressly or impliedly barred. Okay? And these are the expired bar. Just now we discussed about the implied bar. Okay. Next, in which court you would file a case? Section 15 of CPC says that you should file a suit in a lowest grade competent court. Lowest grade competent court. Okay. From here, this is called the inherent jurisdiction of civil courts. Okay? And from now, this is called the territorial or pecuniary jurisdiction. And Section 16, my friends, of CPC says that Suits relating to immovable properties like vacant sites, lands, or house sites or apartments, anything immovable properties should be filed in a court within whose local limits of jurisdiction such immovable property is situated. You get the point? This is okay. And section 17 says, for example, if the immovable properties of A are situated in different jurisdiction of different courts, then suits can be filed in any one of such courts. Okay, that is called section 17. That is section 17. Section 18 says, when there is an uncertainty regarding the immovable property, where it is situated, then a suit can be filed in any court, provided the court shall record its reasons for uncertainty and try the suit. That is called section 18. Section 19 of CPC says, when a wrong is done to a person or immovable property, not immovable property, movable property, the suit shall be filed where such wrong actually done, or where the defendant resides. Okay, this is section 19. And section 20 says the other cases, other than these cases, says where the defendant or one of the defendant resides, or where the cause of action wholly or partly arises. Okay, where the defendant resides can be, we know all. Cause of action. Cause of action, my dear friends, means immediate accruing of right to the plaintiff to file a suit before a civil court. The Supreme Court, in beautiful terms, it defined the cause of action. Cause of action has not been defined in CPC. For that matter, even the what is the suit has also not been defined in the Code of Civil Procedure 1908. Cause of action, as defined by Supreme Court, is, my friend, every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to get a judgment from the court. Okay? This is called cause of action. Simply, when time ripened to file a suit, simply, and you need to prove to the satisfaction of the court that certainly defendant did wrong against me or my property, movable or immovable, therefore I am coming to the court. Okay? Or you may say the bunch of facts which entitle the plaintiff to get a decree from a civil court. That is also called cause of action. Different cause of action, but I rely on the definition of the Honorable Supreme Court, just now which I read earlier. Okay, friends, there are certain contracts regarding movable properties. Let us assume A and B entered into a contract regarding immovable property or business. Here, B resides in Kolkata. A resides in Mumbai. Contract was executed at Delhi. Okay? If contract is violated, all these courts will get jurisdiction. Okay, so far as the immovable properties or business or anything concerned, not immovable property, bear in mind. Okay, and at the same time, A and B also can write a clause in their agreement boosting the jurisdiction of these courts, and they can confer the jurisdiction on courts of Calcutta exclusively. That is called ouster of jurisdiction or ouster of jurisdiction, as you may call, as I call. Okay? Ouster of jurisdiction. Suppose, let us assume a property X is situated in Kolkata. that is Kolkata, that is 2 acres of property, and its owner is A. B, resident of Mumbai, purchases this property and wants to develop that property by constructing apartments. Here they enter into a contract whereby A and B, where A and B, who state the jurisdiction of Mumbai court, who state the jurisdiction of Kolkata court, and confers the jurisdiction on the courts of Mumbai for the purpose of contract. But the Honorable Supreme Court way back in the year 2006 has reiterated that usurp of jurisdictions, the concept of usurp of jurisdiction is not applicable to the immovable properties. Necessarily, A or B has to file suit in courts of Calcutta where this property is situated. Okay, you get the point. For you can, by contract, you can in cases other than immovable property, you can confer jurisdiction on any court, even though where you do not reside. Okay, that is contract, mutual contract between. But when it comes to immovable property, you need to file the suit where within the local limits of the jurisdiction of whose court, there only you need to file the civil suit. Okay, you get the point? Okay. This is, friends, this is territorial jurisdiction. This is inherent jurisdiction. These are called territorial jurisdiction. Friends, territorial jurisdiction has to be decided by the government in consult with the High Court of concerned state regarding the territorial local limits of the civil courts. Likewise, the pecuniary jurisdiction of the civil courts is also defined by the Civil Courts Act. I believe every state has its own Civil Courts Act. Like we have the AP Civil Courts Act 1972. As per section 15 of AP Civil Courts Act 1972, the government and the High Court shall prescribe the local limits of each court. Junior Civil Judges Court, Senior Civil Judges Court, District Judges Court, etc. etc. And section 16 of the AP Civil Court 1972 speaks of pecuniary jurisdiction of Junior Civil Judges Court, Senior Civil Judges Court, and District Judges Court. Likewise, another section is there in the AP Civil Courts Act regarding the filing of appeals against the decrees of Junior Civil Judges Court, Senior Civil Judges Courts, and District Judges Court in terms of the pecuniary jurisdiction. Okay, normally the High Courts will not have original jurisdiction to try a suit. Only the appellate jurisdiction or the special jurisdiction under Article 226 or revisional jurisdiction under Article 227 and or 115 of Civil Rules of Civil Procedure Code. Okay, but some courts have also jurisdiction, like Madras High Court has original jurisdiction, and the Allahabad High Court has original jurisdiction to try any suit according to its pecuniary jurisdiction. And likewise, the Delhi High Court has also the jurisdiction. But Andhra Pradesh High Court and Telangana High Courts have also original jurisdiction in respect of the matters relating to sea disputes, port disputes. Likewise, there is the maritime. Maritime suits can be filed in High Court directly. Okay. These are the jurisdictions: pecuniary jurisdiction, inherent jurisdiction, territorial jurisdiction. Okay. These are the okay for today. That's enough now. Next time we will be discussing the drafting of planes. Okay. Have a good day. If you like this video, please press the like button. If you want such classes in the near future, please subscribe my channel and press the bell button so that you may receive notifications from my channel. Okay, thank you.